Major Second Amendment case is before the Supreme Court today.
Stricter gun laws took another step to become reality, passing the Senate just a few days ago. The bill would prevent the sale of certain firearms.
The ruling class just can't seem to avoid trying to trample all over and infringe all of our firearm rights.
You can take two clips, you can put them side by side, and then you've just doubled the magazines by having them attached to one another.
This is not some gun rights attorney saying it. This is the U.S. government admitting it. They're saying these laws don't survive Bruen.
We could be looking at the perfect storm of Second Amendment cases all landing in front of the Supreme Court at the same time.
The Supreme Court is about to face something it has been dodging for years, and this time there may be no way out. Two landmark gun rights cases are converging on a single conference date, February 20th, and they are not coming alone. Multiple additional challenges to rifle bans and magazine bans across the country are stacking up for that exact same conference. This is not a coincidence, this is a collision course, and what happens next could permanently reshape the Second Amendment landscape in America. Let me explain why this particular moment is unlike anything we have seen in recent memory, and why the outcome of this single conference could determine whether millions of lawfully owned firearms remain legal or become contraband overnight. For years, the Supreme Court has sidestepped the most fundamental question sitting at the heart of modern gun rights litigation. It is a deceptively simple question, but the answer carries enormous consequences. Does the Second Amendment protect commonly owned semi-automatic rifles like the AR-15 and standard capacity magazines? That is it. That is the question that lower courts have been wrestling with, contradicting each other over, and essentially making a mess of for the better part of a decade, and the Supreme Court has just watched it happen, declining case after case, letting the chaos grow deeper and more entrenched with every passing term. But now, something has shifted. The conditions that multiple justices have hinted they were waiting for appear to have finally materialized. And to understand why this is so significant, we need to look at the two anchor cases driving this moment forward. The first is a case out of Cook County challenging the local ban on so-called assault weapons. This ban sweeps up AR-15s and dozens of other commonly owned rifles under a broad prohibition. The plaintiffs in this case are making a straightforward argument rooted directly in the Supreme Court's own precedent. These rifles are in common use by law-abiding citizens for lawful purposes. Under the framework established by prior landmark rulings, arms that are in common use are constitutionally protected. Therefore, a blanket ban on an entire class of commonly owned firearms violates the Second Amendment. The ask here is clear. They want the Supreme Court to definitively state that states, counties, and cities cannot simply outlaw firearms that millions of Americans legally own and use every single day.
Virginia Democrats are moving forward with several bills they say are meant to reduce gun violence in the Commonwealth.
So we are heading towards one of the most important Supreme Court moments for gun rights in many years.
For a decade, there was a ban on so-called assault weapons and high-capacity ammunition magazines.
What they've done now is they have modified their assault weapons ban so that it touches not just assault weapons, but magazines.
We've got to have good mental health screenings, and we've got to have appropriate judicial oversight.
Multiple other rifle and magazine ban challenges are lining up for that same exact conference in the Supreme Court.
The second major case involves California's ban on magazines that hold more than a certain number of rounds. This case has a particularly interesting history because it was previously taken up by the Supreme Court, then vacated and sent back down to the lower courts after the landmark Bruen decision reshaped Second Amendment analysis. The idea was that the lower courts would reconsider the magazine ban under the new historical framework that Bruen established. But here is what happened instead. The lower court went right back and upheld the ban anyway. So now this case has climbed all the way back up to the Supreme Court, essentially saying, we tried it your way, the lower courts are not listening, and we need you to step in and settle this once and for all. Now here is where things get really interesting, and this is the detail that elevates this moment from significant to potentially historic. Both of these cases have been relisted. In Supreme Court procedure, a relist means the justices did not deny the case outright. They did not grant it either. Instead, they moved it forward to be discussed again at a future conference. And not just once, these cases have survived multiple rounds of conference without being denied. That is a meaningful signal. When the Supreme Court wants to reject a case, it typically does so quickly and quietly. The fact that these two cases keep getting pushed forward, kept alive, discussed behind closed doors by the justices, tells us that something is happening internally. But the truly critical piece of this puzzle is the conference date itself, February 20th, because these two cases will not be sitting on the table alone. Multiple other challenges to rifle bans and magazine bans from different states and different circuit courts are also scheduled for consideration at that exact same conference. We are talking about a cluster of cases all raising the same core constitutional question, all arriving at the Supreme Court's doorstep at the same time. This is not an accident.
People think this extends just to rifle mags. It does not. It extends to any magazine capable of accepting over 10 rounds.
Cannot ban an entire class of firearms that are commonly chosen by law-abiding citizens.
Virginia Democrats are moving forward with several bills they say are meant to reduce gun violence in the Commonwealth.
Two major cases, a rifle ban and magazine ban, are now heading to Supreme Court conference on February 20th.
Pro-gun control groups and Democratic lawmakers are working to ban high-capacity magazines and other types of weapons on a federal level.
And to understand why it matters so much, you need to understand a pattern that legal observers have been tracking for years. One of the most common criticisms leveled against individual gun rights cases when they reach the Supreme Court is that the specific case being considered is somehow the wrong vehicle. Maybe there are procedural complications. Maybe the factual record is not clean enough. Maybe the lower court ruling was narrow in a way that makes it difficult for the Supreme Court to issue a broad decision. Anti-gun advocates and opposing counsel have used this argument repeatedly to discourage the court from taking up any single case. And frankly, it has worked. The court has used these kinds of concerns as justification for turning cases away term after term. But when you have multiple cases from multiple states, decided by multiple circuit courts, all presenting the same fundamental question with different factual records and different procedural postures, that excuse evaporates. The court can no longer say there is no clean vehicle. They have a whole fleet of vehicles parked right in front of them. They can pick the best one, or they can take several and consolidate them. Either way, the argument that the court cannot or should not act because of case-specific issues becomes almost impossible to sustain. And this is precisely the scenario that certain justices have been publicly signaling they wanted. When the court declined to take up rifle ban cases in a previous term, there were notable statements from individual justices expressing frustration. One justice in particular indicated that the court should and would address the constitutionality of these bans within a term or two. That was not a casual remark. That was a public commitment made from the bench, and it set a clock ticking. Well, that clock is now running out. This is the term. This is the conference. And the cases are here. So what are the possible outcomes and what should we be watching for? The first and most consequential possibility is that the Supreme Court grants review in one or more of these cases. If that happens, we are looking at full briefing, likely beginning in early spring, followed by oral arguments, and potentially a major Second Amendment decision before the current term ends. A grant would signal that the court is finally ready to draw a clear line on whether commonly owned semi-automatic rifles and standard capacity magazines fall within the protection of the Second Amendment. Given the current composition of the court and the analytical framework established by Bruen, there is strong reason to believe that such a ruling would come down firmly on the side of constitutional protection. That would have immediate and sweeping implications for every rifle ban and magazine ban currently on the books in states like California, New York, New Jersey, Illinois, and others. The second possibility is that the cases are relisted yet again, pushed to another conference for further discussion. While this would be less dramatic, it would not necessarily be a bad sign. Additional relists could indicate that the justices are still working to coordinate which cases to take, how to frame the question presented, or whether to consolidate multiple cases into a single grant. It would extend the timeline but keep the door open. The third possibility, and the one that gun rights advocates are most concerned about, is an outright denial. If the Supreme Court denies all of these cases, it would send a deeply troubling message. It would mean that despite the clear circuit split, despite the lower courts openly defying the Bruen framework, and despite explicit promises from sitting justices, the court is still unwilling to engage with this question. That would effectively leave millions of Americans subject to bans that many legal scholars believe are unconstitutional, with no realistic path to relief. But here is why outright denial feels less likely this time around. The sheer volume of cases converging on this single conference makes it very difficult for the court to look the other way. Denying one case can be explained away. denying a dozen cases, all raising the same question from courts that are openly contradicting each other. That is much harder to justify, especially when members of the court have already publicly acknowledged that this issue needs to be resolved. There is also the broader legal context to consider. The Bruen decision fundamentally changed how Second Amendment cases are supposed to be analyzed. It requires courts to look at the text, history, and tradition of the right to keep and bear arms. Under that framework, banning commonly owned firearms that have been legal and widely used for decades is extraordinarily difficult to justify historically. The lower courts that have upheld these bans have done so by stretching historical analogies to their breaking point, and in some cases by essentially ignoring Bruen's instructions altogether. The Supreme Court has to be aware that its own precedent is being undermined in real time. Letting that continue unchecked would erode the authority of Bruen itself. So where does all of this leave us right now? We are 1 week away from what could be the most consequential Supreme Court conference for gun rights in years. Multiple cases challenging rifle bans and magazine bans are all converging on February 20th. The two lead cases have survived multiple rounds of relisting, signaling active deliberation among the justices. The conditions that the court has been waiting for, a clear circuit split, multiple vehicles, and a well-developed factual record, are all present. And the promise made by at least one justice to address this issue within a term or two is now due. The week following the conference, the court will release its order list, and we will know whether these cases have been granted, relisted again, or denied. That order list will tell us whether the Supreme Court is finally ready to answer the question that has been hanging over the Second Amendment for years. Are the most commonly owned rifles and magazines in America protected by the Constitution, or can the government simply ban them? The answer to that question will affect tens of millions of gun owners across the country, and we are days away from finding out whether the court is willing to provide it. That's it for today, folks. See you in the next video.